Good morning. Trust you can all hear me. Yes, yes, nodding, thank you. So it is 10 o'clock, so it's time for me to open the inquiry. My name is Mark Brooker. I'm a Chartered Town Planner. I've been appointed by the Secretary of State to hold this inquiry. The inquiry is into an appeal by Hallam Land Management Limited against the failure of Maidstone Borough Council to determine the application within the appropriate time period. The description of development is detailed on the appeal form. There's an outline application, all matters reserved other than principal means of access to the highway for the removal of existing polytunnels on land north of Kenward Road and the erection of up to 112 dwellings, use class C3, associated infrastructure and landscaping, together with a change of use of land south of Kenward Road to provide informal and recreational open space, sustainable urban drainage features, landscaping and ancillary works and infrastructure, and the site described as land north and south of Kenward Road in Yalding. Before we start, some minor housekeeping items. There's no fire alarm drill planned, I understand, so if an alarm does go off, we can just evacuate the building back down through the doors you came through down the stairs. Toilets and the like are downstairs. I understand you're able to come and go. Public access to the building is ensured, so thank you for that. If I can start off with running through the appearances, please, for the parties. Mr. Tucker, I presume?
Yes, sir, thank you. I think both myself and Mr. Henderson, who acts for the authority, have both been diligent. If you look to your left side, sir, both of us have placed a list of appearances there. So my name is Paul Tucker. I'm King's Counsel. I act together with my little friend, Mr. Carter, who sits at the end of the table, also of counsel. I propose to call two witnesses, sir, but you'll see three listed. Those are, in relation to matters of landscape, Mr. Andrew Williams, who's the Director of Define. In relation to planning, Mr. Adam Ross, who's the Director of Nexus Planning, and also my instructing consultant. And in relation to highways, so you'll see that we produced documentation from Melanie Elie, who's the Director of Brookbanks, who's available in the event that there are any questions which you may have, so, or in the event that anything arises.
Thank you, but it's not your intention to call the witness at this stage.
It's not necessary, so it's not an issue between the parties.
And with apologies for the limitations of the English language, Miss, Mrs, Doctor, or in Mrs. Thank you. Thank you.
Thank you, sir.
Sir, good morning. You also have the appearances on behalf of the Council in writing on the second sheet before you. My name is Matthew Henderson. I'm instructed by Mr. Russell Fitzpatrick, the team leader in the planning department at the Maidstone Borough Council. I have two witnesses. The first, Mr. Stephen Kirkpatrick, the director at SCARP, who deals with landscape matters. And secondly, Mr. Sean Strott, who sits to my right, a principal planning officer at the Council, who will deal with the planning balance matters.
Thank you. Anybody else wishing to speak at the inquiry? Yes. Sorry, Dorothy. What was your surname? Oh, sorry, Geraldine. Would you mind stepping forward and just use the microphone to help me? If that would be okay, thank you. If you mind jumping up and just press the button. I have one successful complaint against me in my career at Pins, and that was because I spelled somebody's name wrong. So I don't wish to repeat that, so apologies if I labour it, but I would like to get it right. Just press the button and we're away.
Yes, sorry, it's Geraldine Brown, and I'm chairman of Yalding Parish Council. I am. Objections? Yes, certainly. I do have my clerk with me as well, in case I'm not fully up to speed with anything. No. Thank you.
So if anyone's having issues viewing online, they can contact planning technical team at maidstone.gov.uk.
I presume no one has any objections to this?
No objections, just a question whether or not it's going to be live streamed even during the breaks. I only say that having seen a different inquiry, happily not involving my team, but during breaks, conversations with another team have then been broadcast to the world, which didn't go down very well. So I don't know what the answer to that question as to whether or not it's going to be live streamed even when we're adjourned, but it'd be useful to know.
Do you know, is it paused during breaks? Or?
I will be pausing the live stream during the breaks.
Okay. Thank you. Thank you.
Thank you, that's helpful.
Okay. Notification letters. I've received copies of the Council's notification letters, particularly confirming the details of the appeal, the date, time and location of the inquiry. I did notice a slight discrepancy of the dates of the second week within that notification letter. Obviously the first dates and location and times was correct. I think it referred to the Monday, but given some of those dates have changed anyway now, particularly in respect of the 5th day, Wednesday, we're currently not planning on sitting, and indeed Tuesday, the 24th, where we are planning to do that virtually, if that's still the case. So that has changed, but I would like that note updated on the Council's website if that's possible, just to be quite clear. Obviously the start date and everything else was correct in that notification letter. Thank you. I have had copies of all of the responses made in respect of the appeal and the original planning application, and I will take those into account in reaching my decision. Are the parties happy that they've had all those copies as well? Yes.
We are, sir. Thank you.
Thank you. We held a case management conference call sometime prior to this inquiry. It didn't talk about the merits. We heard no evidence in respect of it. It was just to ensure the smooth running of the inquiry. I understand a copy of that note is available on the Council's website, should anyone wish to be interested enough to look at it. Thank you. Excellent. And I've received proof of evidence from the appellant and from the Council, indeed, including the third witness, which you don't intend to call at this stage. Thank you. The procedure will follow the normal procedure, and rather than a topic-based approach, I think it's easier, given the disputes. It's going to be heard from first the Council and then the appellant's evidence. On my timings I set out earlier today, I sent out earlier previously, once I've run through the opening matters, we have all of the opening statements from the appellant and from the Council. I'll then try to run through the interested parties, any particular comments you have then, before we break in the afternoon, and then we come back to Mr. Kirkpatrick for the Council. Is that still correct? Everyone happy with that? On the matter of some of those timings, we do have some quite challenging days, perhaps some quite intensive days going forwards to fit it all in. In particular, I noticed some of the cross-examinations, I think I described them being somewhat disproportionate. Some of the witnesses, what do the advocates feel about that? Mm-hmm.
In dispute. But I think as an overall point from our perspective, we feel everything that you've got planned for days 1, 2 and 3 will be completed within those 3 days.
Happy to bring that in. And on that particular point of cross-examination, evidence in chief, I have quite a low threshold for aggressive cross-examination. It doesn't do very much for me, I'll be quite honest. Equally so, I do expect witnesses to answer the questions, yes, no, qualification. I'm sure people who have any experience of inquiries will know barristers, you are, in cases you are wily creatures. They may even suggest things that you agree with at times. That case may be the point. And indeed, if the witness does adopt and stick to a slightly absurd position, leave them there, highlight it to me, is often better than badgering them constantly for a question and an answer they're not going to give. Thank you for that. The site visit. I currently don't have a vehicle with me. I can get one, but you have set out for me, helpfully, an itinerary for the site visit. So the parties may wish to put their minds how they wish to execute that. In the past, I've had a minibus. Otherwise, I've done a self-driving tour of the points that have been highlighted to me. In common with most site visits these days, I wouldn't have any discussion on site. If you want to particularly point out anything for me in evidence of the rest, I would hear it here before I go out on site, and we do that there. But I'm not planning on doing that site visit until the Thursday in the afternoon, once I've heard the evidence for that. Thank you. The conditions and obligations as well. Once I've heard the evidence, we do have to run through conditions and obligations, which for the benefit of the interested parties present, this doesn't suggest that I've made up my mind or indeed that the council have conceded their case. It's just a necessary process we have to go through. If I were minded to allow the appeal, I know what conditions I would want to attach to any planning permission that results from it. So on that point, and skipping slightly forward, I have a copy of the draft section 106. I came through late on Friday. I understand you're still checking that. Is that correct?
So I got a message about half an hour or so ago through those instructing me that the parties were virtually there in relation to that. There are a couple of minor matters to be tweaked. Indeed, the email promised that we would probably be there by 10 a.m, though I've not heard anything since. So we're imminently to be agreed in relation to that. I also, Mr. Henderson and I have had a discussion about the SIL compliance schedule, which I suspect may be next on your list. I'm told that that can be made available shortly, which will be splendid, certainly before the planning evidence.
Mr. Henderson, anything different there?
No, the 106 I understand is essentially agreed, and the SIL compliance statement, yes, that will be printed out and made available later today, I hope.
Thank you. And yes, indeed, to the next thing on my list to tick off. So just sticking with the section 106, I assume that the content of the section 106 would largely resolve the second main issues that I raised at the casework management conference relating to affordable housing and various offsite highway works.
Yes, sir. I think as between the council and the appellants, we're locking horns on the first putative reason for refusal only. The others resolved by the 106 as set out in the statement of common ground. So you're right, sir.
Thank you. And regarding the draft conditions, I understand these are with the appellant at the moment.
No, I think they're with the authority still. But there's been a number of to's and fro's, but I think they're with the authority. There has been a version which I think was sent to the planning inspectorate late yesterday. I don't know whether that's reached you yet, but it's a work in progress. Certainly our intention would be that at an appropriate point during the course of today, that our planner, Malone Friends planner, will have a conversation to try and narrow the issues well in advance of the condition session. If necessary, we can lock them in a room, sir.
Thank you. I think I'm probably one step behind them because I haven't received an update email.
That came through to us yesterday evening, I'm told. I'm happy to have a discussion today, see if we can move matters forward before Thursday.
Thank you. So I'll just reiterate my desire for the conditions to be presented in an editable Word document. I'm quite a fan of the condition on one side, then 2 columns of the council's comments, the appellant's comments, and indeed, being a planning inspector, I will make my own changes to those. But if I could get those sooner rather than later, that can make the best use of the inquiry time in the roundtable discussion later. I'll be grateful for that. Thank you. The plans that have been submitted to me, I don't presume there's no additional plans to be sent to me now?
No, sir.
No other documents, thank you. Now, a number of the plans have a sort of status of either having been superseded or are illustrative plans, and I would treat them as such when considering them and making my decision as well. In particular, that's the likes of the illustrative master plan that I would treat again as being illustrative. And
so can I just ask, so for my convenience, I asked for a copy of the relevant plan to be printed out at A3. I think we have at least one extra copy. I don't know if they're handy for you to have. So you've got those immediately to hand.
They can be helpful, particularly if they're going to be referred to in evidence.
So we'll make sure those are passed up in due course. Thank you.
I've already talked about the draft 106 and the conditions. Are there any other documents intended to be handed out other than the plans that perhaps we might have. There was some discussion around whether or not landscape and visual impact assessment guidelines was going to be available. I don't know if there's been any advancement on that, Mr. Henderson.
Yes, that's all been taken care of yesterday, I understand, and it's been added to the core document, so as and when that's required, that is there.
Thank you, most helpful.
So the only document that we'd want to hand to you, in addition to the plans, is at the back of Mr. Williams' evidence in his rebuttal. It's an Excel spreadsheet, so if one prints it out, sometimes it comes out as quite small writing. So we've got a copy which is at a larger scale, which I don't know if that will be helpful to you, sir.
Quite possibly, yes. That would be helpful, thank you.
We'll make sure that's put on your desk as well, sir.
Okay. And I will, as I receive these documents and your attendance list and like, enter them in as inquiry document 1, 2, 3, etc. Those who wish to keep a note of that. Thank you. Well, that concludes my procedural matters and opening remarks. We can move on to essentially dealing with that main issue being the effect of the appeal scheme on the character and appearance of the area, including the setting of the green sand ridge landscape of local value. And Mr. Tucker, if you'd like to go through your opening.
I will, sir. So I've condensed it to writing as requested, and I wonder if that can just be circulated. Copy to yourself, copy to my learned friend, and then copy to the third party. Yes, I've got a copy. You've got one. Yes. It's very sweet that Mr. Ross thinks I may not have a copy. Yes. So I'll stick to text. If I deviate, I'll indicate that I've deviated. So this is an inquiry that, if the council had approached matters correctly, we say would not be taking place. At a time of national housing need and within a matter of months of the adoption of the local plan, we think it's baffling how any council can find itself arguing that permission on an allocated site should be withheld for an outline proposal which on any view proposes development in accordance with the site's allocation for approximately 100 dwellings. The council's case is characterised by inexplicable but fundamental omissions and errors of approach for reasons that we'll briefly touch on now but explore further in evidence. Having been guilty of delay and a lack of responsiveness in dealing with the application, which prompted my clients to appeal for non-determination, the council has now determined that it would have refused the permission for a total of 5 reasons, 4 of which are resolved by the imposition of suitable conditions in combination with the planning obligation that my clients have always been willing to provide. The only issue of substance left for the inquiry to consider is that encapsulated by the putative reason for refusal number 1, which raises the main issue of the effect of the appeal scheme on the character and appearance of the area, including the setting of green ridge landscape of local value. The fundamental starting point is that the appeal is allocated for housing development in the very recently adopted local plan under policy LPR, so Local Plan Review SA248, for the purposes of approximately 100 homes at a density of approximately 1 hectare. In allocating the site for development of that nature, the council and the examining inspector must, mentally underlined, must have been satisfied that such an allocation was sound. It is not open to the council to seek to now say that the allocation wasn't actually based upon a capacity assessment and that this level of development in the policy, I add, remains somehow a matter to test at the application stage, and that the inspector's endorsement of the allocation was for the site's development for a wholly unknown and unproven number. Can I just add, sir, where the plan expects numbers to be determined, it says TBD within it. Mr. Ross shows how, when the plan is read as a whole, with reference to approximately 100 dwellings, that figure can only be sensibly referring to an approximate minimum figure. The appeal scheme self-evidently falls within the nature of development envisaged by the development plan, both in terms of numbers and density. One can think of any number of ways of expressing this. For example, sitting as you do, sir, here, it's 114 miles as the crow flies from Yalding to Portsmouth. Or put another way, it's approximately 100 miles. Or perhaps 40 ounces in imperial measurement is 1.12 kilograms in weight, or approximately 1 kilogram. However, it is not necessary to embark upon such forensic or linguistic analysis of what approximately means. which is frankly a matter of obvious judgment anyway. Rather, as Messrs Williams and Ross set out, it is vastly more useful to assess the effects of the appeal scheme for outline permission as compared to the reasonable interpretation of the terms of the allocation. Such a comparison shows the appeal scheme is perfectly appropriate. Our case, sir, is the essential issue when testing putative reason for refusal 1 is to ask what are the land use impacts that would arise through permitting the appeal scheme of 112 homes over and above those that must have been considered to be acceptable when the allocation was proposed, examined and adopted, a scheme of approximately 100 homes. That's a task which Mr Kirkpatrick mentions in passing in only 3 paragraphs of his proof, with which he never properly grapples. Where one might reasonably ask is the assessment of where approximately 100 would be okay as an outline permission, but 112 isn't. The Council fails to show why the appeal scheme would be unacceptable in the context of the allocation. Large parts of Mr Kirkpatrick's evidence also simply fails to recognise the consequence of the appeal scheme being an outline application, because he addresses matters which on any sensible view are issues to be addressed at the reserved matters stage, as Mr Williams shows in his rebuttal evidence. Mr Williams' assessment shows that the impacts of the appeal scheme on the character and appearance of the area will be totally acceptable when seeing the context of the allocation in the plan. The design of the scheme clearly was shaped by the DAS and the landscape and visual appraisal process and was landscape-led. The LVA provides a clear basis for assessing the scheme properly, and the criticism of it leads nowhere and doesn't assist practical decision-making. The scheme would provide ample scope for significant landscaping around the site's boundaries and within it to break up the development, soften its edges and integrate it successfully into its surroundings. The relationship between the appeal scheme and the LLV would actually be improved as compared to the existing position. Insofar as design issues are engaged by an outline application, the appeal scheme clearly responds positively to its setting on the edge of Yalding, and it isn't at odds with the village's present character. The parameters plan supporting the appeal scheme implies a density of 33.4 dwellings per hectare, which is wholly in keeping with the surrounding character, and indeed a comparison of developing 100 dwellings at 30 dwellings per hectare with the appeal scheme's numbers and densities shows the appeal scheme would increase the net developable area by a mere 0.02 hectares. It's actually 0.016 recurring. The details of the arguments will be explored in evidence, but one might reasonably note that Mr Kirkpatrick's written evidence does not grapple at all with this second equally obvious question. Mr Williams' evidence shows the provisions of the allocation that are relevant to the character and appearance will be complied with. Mr Ross addresses other matters to show the appeal scheme would comply with the development plan taken as a whole. The execution of the appeal scheme in accordance with the adopted allocation will bring obvious benefits through the delivery of up to 67 market homes and up to 45 affordable homes. Over 25% biodiversity net gain, significant delivery of open space in the context of a settlement having a deficiency of open space in both quantitative and qualitative terms, and economic benefits which will be realised in Yalding, the borough and the wider area. Those benefits ought to be realised in the public interest as the development plan itself has envisaged. The appeal scheme accords with the allocation and with the development plan taken as a whole. There are no material considerations which would indicate taking a decision otherwise than in accordance with the recently adopted local plan review, and it ought to have been allowed to proceed without delay. Finally, sir, it's worth noting this. Amongst the various discussions about planning reform intended to actually boost the supply of housing is the notion that the cost test might be reversed, and where there is refusal of permission on an allocated site in an up-to-date plan, that it would be for the council to demonstrate its refusal was reasonable. On its own case, in this case, it's failed to do that. Whilst the council's planning evidence recognise, albeit reaching the wrong conclusions, that the question is what exactly is the benefit of the extra 12 units over the allocation of 100, with the greatest respect, the council's landscape case to date doesn't provide even the most cursory attempt to show what the harm would be of those extra units referred to in Mr Scott's evidence. And pretending that the local plan examiner didn't assess a capacity for an allocated site is an exercise in wishful thinking, not reasonable planning. In due course, sir, we will be inviting you to allow the appeal. You'll be unsurprised to hear, having heard all that. So unless I can assist you further, those are our submissions in opening.
Mr Henderson.
So Maidstone Borough Council has an enviable track record in planning for and, most importantly, delivering new homes for the people in this borough. The council has over-delivered against its housing requirement in the adopted local plan review since the start of the plan period in 2021 by more than 500 homes. This follows a longer period of over-delivery under the previous local plan. Under that plan, the council over-delivered by more than 1,000 homes against its housing requirement before the adoption of the local plan review. This strong delivery was, and continues to be, driven by the plan-led system. For example, 86% of the allocations in the previous local plan, amounted to more than 8,000 homes, had obtained planning consent before the adoption of the local plan review, with more than 5,000 dwellings completed. This picture demonstrates, unequivocally, that the council's approach is one which has already significantly boosted the supply of housing in the borough. This is an approach which will continue. As the examining inspector concluded, the local plan review will firmly deliver a significant boost in housing supply, consistently with the NPPF. Indeed, the local plan review requires 31% more houses per year on average when compared to the local plan. The local plan review was adopted in March of this year, replacing the local plan which was itself adopted in October of 2017. The short gap between the adoption of these plans, just 6.5 years, even allowing for the pandemic and a prolonged public examination, is a further indication of the council's proactive approach to strategic planning. This is an approach which stands out in Kent. The majority of the council's neighbouring authorities are operating under development plans which were adopted more than 10 years ago. None of the neighbouring authorities have a development plan which was adopted in the last 5 years. Similarly, the council's supply picture, a housing land supply position of 6 years, also stands apart from its neighbours. All of the neighbouring boroughs in Kent have less than 5 years housing land supply. The ease with which these figures can be reeled off in a few short paragraphs belies the difficulty of planning for housing growth in this borough. Not only did the local plan review have to address a significant uplift in the housing need, but it had to do so in a mainly rural borough. The rural hinterland of the borough is a high-quality environment, including areas within 2 national landscapes, the Kent Downs and the High Weald, as well as multiple landscapes of local value. These conflicting matters, significant housing growth and the protection of a high-quality environment, gave rise to competing strategic objectives, which the council had to balance in the plan-making process. The result of that balancing exercise is the spatial strategy, including the allocations and the supporting strategic policies in the local plan review. These policies create a framework which, as the local plan review itself explains, is the why, what, where, when and how development will be delivered for growth and renewal, whilst at the same time protecting and enhancing the borough's natural and built assets. Critically, this includes the scale and distribution of development. Overall, the local plan review directs approximately 60% of the planned housing growth over the planned period to locations within and around the Maidstone urban area. This proportion of growth is commensurate with Maidstone's top-tier spatial role. A significant amount of new growth is also planned in the 2 new garden settlements, being the second tier in the settlement hierarchy. Away from these top tiers, much more limited growth is planned. Rural service centres provide a secondary focus for housing development. Larger villages, such as Yalding, in the next tier down below those centres, are locations for only limited housing development, consistent with the scale and role of the villages. The allocation of the appeal site in Policy LPRSA 248, the local plan review, sits in this context. It is an example of planned limited housing development. Indeed, as the inquiry will need to consider, the terms of the allocation itself exemplify the balancing exercise undertaken by the council in the plan-making process. The need for such a limited approach, both in the larger villages generally and Yalding specifically, is a necessary and inevitable consequence of the high-quality environment of the borough. For example, the Yalding farmlands at LCA, in which the majority of the appeal site is situated, is in very good condition and possesses a high sensitivity. Similarly, the Linton Greensand Ridge LCA, broadly the same area as the Greensand Ridge LLV, and sitting only 50 metres to the north of the appeal site, is also in very good condition and possesses a very high sensitivity. In this context, the council has adopted a positive but limited approach to a new housing development. New housing development is permissible, but only when it accords with the council's clear expectations and the relevant preconditions set out in the council's allocation policies. This appeal arises because the appellant seeks to bring forward a development which does not accord with the allocation and which is contrary to the strategic policies in the local plan review that require good design. This is the sort of development which must be resisted, and it must be resisted with equal rigour to that which is mustered against speculative development on unallocated sites. The Council's past and future success depends on adherence to the plan-led approach on both allocated and unallocated sites across the borough. No lesser scrutiny is required on an allocated site. I turn then to the allocation. The allocation establishes that the appeal site, and specifically Site A, is an appropriate location for residential development. There is no dispute about the principle of residential development. Rather, the dispute lies in the scope of the allocation and in the satisfaction of its preconditions. First, to the scope. The allocation permits residential development of approximately 100 dwellings at an average density of approximately 30 dwellings per hectare on Site A. Notably, this is reiterated both in paragraph 1 and paragraph 2. A proposal which is not for approximately 100 dwellings, or an average density of approximately 30 dwellings per hectare, is not in accordance with the allocation. This is the first issue to consider when assessing the proposed development. Is the proposed development within the scope of the allocation? During the plan-making process, the Council did not undertake landscape sensitivity testing or detailed capacity testing by reference to landscape and visual effects. Instead, the detailed assessment of the quantum of development was left over for the application stage, i.e. now, within the parameters set by the allocation. I underline those words, sir. The conditions within the allocation support this approach, and see in particular paragraphs 5 and 15. This is not, as the appellant's opening suggests, paragraph 3, a question of a wholly unknown number. This is about determining the correct quantum of development within the parameters set by the allocation. I turn to paragraph 16 in the written text. It follows that it is through the application process that the acceptable quantum of development must be established, again, within the parameters of the allocation. In particular, the parameters being approximately 100 dwellings at an average density of approximately 30 dwellings per hectare. The fact that the parameter is approximately 100 dwellings means that an acceptable quantum may be above or below 100 dwellings, whilst always remaining approximate to that number. In this regard, there appear to be 2 points of departure in the appellant's approach. First, the appellant fails to recognise, or has misunderstood, the need to establish the appropriate quantum of development within the parameters of the allocation at the application stage. This omission has infected the appellant's approach in the preparation of the application, which is before you now on appeal, and its evidence for this appeal. Secondly, contrary to the impression given by the appellant, and indeed repeated in opening this morning, the descriptions of approximately 100 dwellings and approximately 30 dwellings per hectare are not minima. Put simply, approximately does not mean at least. And I repeat, an acceptable quantum may be above or below 100 dwellings. Similarly, an acceptable density may be above or below 30 dwellings per hectare, whilst always remaining approximate to those figures in both instances. The appellant's approach ignores the ordinary meaning of the word approximately, close in quantity. A number which is close to another but below it is approximate, in just the same way as a number which is close to another but above it. And the context to the allocation does not change this interpretation. In particular, neither the housing requirement in policy LPR SS1 nor the trajectory in Appendix 1 to the local plan review requires the allocation to be read as a minimum. The LPR distinguishes between the housing requirement in policy LPR SS1, a definite number, and the approximate capacity of each of the allocations, a less definite number, reflecting the fact that the contribution from individual sites towards housing supply cannot be fixed precisely at the point of plan adoption. Some allocations are likely to deliver in excess of the approximate figure, and some allocations are likely to deliver at or below the approximate figure. The fact that the trajectory and the housing requirement are not aligned perfectly in the last year of the plan period illustrates this flex. The housing numbers in allocations and indeed other sources of supply have not been slavishly matched to the housing requirement. In any event, the Council's track record of over-delivery gives confidence that the overall picture, which is the only proper assessment of housing requirement and supply, will be a positive one. Compliance with the housing requirement is not measured on a site-by-site basis. And paragraph 7 of policy LPR SP10 is concerned with the approach to neighbouring plans in the context of NPPF paragraph 67. This does not read across to the interpretation of the allocation, which is a policy with a different function and purpose. A minimum number of dwellings for the purpose of preparing a neighbourhood plan does not transmute the approximate figures in the allocation into a minimum figure. The appellant's approach is also inconsistent with that of the examining inspector in the local plan review. For example, in the main modifications to policy LPR SA 146, a minimum approach was replaced with approximately. This substitution, as well as the inspector's reasoning being based on a concern about the constraints of the site, only makes sense if minimum and approximately do not mean the same thing. So too in the allocation. The conditions of the allocation. Paragraphs 2 through to 27 of the allocation specify conditions which are to be met before the development is permitted. These conditions must be satisfied, bearing in mind that the application is for outline planning permission, before planning permission can be granted. A failure to satisfy these conditions will cause a proposal to be in conflict with the allocation, even if it's for approximately 100 dwellings. That is to say, even if it is within the scope of the allocation. And this is the second issue to consider when assessing the proposed development. Does the proposed development comply with the allocation's conditions? 4 of the conditions on the allocation are of particular importance, being those in paragraphs 2, 4, 5 and 15. And those latter 2 conditions bear further consideration now. The condition in paragraph 5 requires the layout and form of the housing element of the allocation to be informed by an LVIA and to incorporate both boundary and internal structural landscaping that responds to the site's topography. The first part of this condition underscores the need to properly assess the site's capacity as part of any application for planning permission, and the second part of this condition was a main modification required by the examining inspector, who concluded that it was necessary to incorporate amendments to identify that landscaping would be an integral aspect of the area of A of the site for housing, both around its boundary and within the development itself. In his view, this is necessary in response to the site occupying rising land on the river valley side. This reasoning underlines the importance of satisfying this condition in full in this case. The condition in paragraph 15 reiterates that the development proposal should be designed to take into account the results of a landscape and visual impact assessment, undertaken in accordance with best practice guidance. The clear import of this condition is the need to adopt an evidenced, landscape-led approach to the design of any development proposals. These conditions are of particular importance because they, along with others, most notably in paragraphs 8 through to 14, are a site-specific manifestation of the balancing exercise that the Council has undertaken during the plan-making process. The allocation does not permit residential development simpliciter, rather it permits residential development subject to the defined conditions, all of which ensure that the appropriate balance is struck between housing growth and the other competing site-specific imperatives, most particularly the sensitive landscape in which the appeal site and Yalding sit. To the effects anticipated by the allocation. It follows that whilst the allocation anticipates a change in the character of the appeal site, this is only to the extent necessary to accommodate approximately 100 dwellings. Bearing in mind, of course, that the precise number may be above or below that figure. And, even then, whilst ensuring that a landscape-led approach is adopted so that the adverse impacts of any development on the character and appearance of the area are minimised and mitigated so far as possible, and the beneficial impacts on the character and appearance of the area are maximised. The allocation, in conjunction with the other strategic policies, in particular LPR SB 15, does not permit avoidable harm to the character and appearance of the area. This is the third issue to consider when assessing the proposed development. Does the proposed development deliver change in line with the expectations of the allocation and without causing undue harm? As already foreshadowed, the allocation is not a free pass to cause any amount of harm to the character and appearance of the area in the delivery of housing growth. The proposed development. The proposed development is unacceptable and fails to comply with the allocation and supporting development plan policies on each of these 3 key issues. First, the proposed development is outside the scope of the allocation and fails to comply with the condition in paragraph 2. The proposed development is not a development of approximately 100 dwellings at an average density of approximately 30 dwellings per hectare. The proposed development proposes 112 dwellings, some 12% more than the figure in the allocation, at a density of 33.4 dwellings per hectare, some 10% more than the figure in the allocation. Neither the number of dwellings nor the density is close to the respective approximations in the allocation. This departure is unexplained and unjustified. Nowhere does the appellant explain or even attempt to explain why or how it settled on a capacity of 112 dwellings. The Council's position is that there is no good reason for this departure from the allocation. Secondly, and in any event, the proposed development fails to comply with the other conditions in the allocation. In particular, the proposed development has not been informed by a robust LVIA. It has not been designed to take into account the results of a robust LVIA, and it does not incorporate boundary and internal structural landscaping which responds to the site's topography. The parameters plan which has been produced is unacceptable as a result. Thirdly, and again in any event, The proposed development results in a level of harm to the character and appearance of the area which exceeds that anticipated by the allocation and which is unacceptable by reference to policy LPR SP15. The choice of 112 dwellings at a density of 33.4 dwellings per hectare has resulted in an undue harm to the character and appearance of the area. The harm would be mitigated further or avoided by a development which was at or below 100 dwellings and at or below 30 dwellings per hectare. Contrary to the impression given by the appellant's evidence, a development reduced in scale by 12 dwellings would result in material improvement, particularly to the perimeter and internal landscaping provided, the grain of the proposed development, the effect of the proposed development in near and longer distance views, and in the proposed development's relationship with Yalding. On any one of these three issues, the Council's position is that the proposed development is unacceptable, such that planning permission should not be granted. The combined effect on all three issues is that this conclusion applies with even greater force. The benefits of the proposed development do not outweigh the unacceptability of the proposed development on any of these issues, and they do not outweigh the conflict of the development plan, read as a whole. The Council has a positive and demonstrably successful plan for future housing growth in the borough. The appeal site can and should be part of that future, but the proposed development cannot. The proposed development does not meet the clear expectations in the development plan, and it should not be permitted. The ultimate benefit of the Council's positive approach, in particular its positive housing land supply position, is that it provides flexibility. There is no overriding imperative to permit development which fails to meet the expectations in the development plan. Rather, as in this case, there is breathing space to refuse to grant planning permission and to require the applicant to think again. The Council submits that this is the proper approach in this case. So for these reasons, which the Council will develop through its evidence and submissions, we submit that in due course the appeal should be dismissed.
Thank you. And for those who wish to make a note, I've entered appearances for the appellant as inquiry document 1, the Council inquiry document 2, the appellant's opening as inquiry document 3, and the Council's opening as inquiry document 4. And time's now 11:15, so I think that quite neatly allows us to move on to the interested parties before we have a break, perhaps for lunch. So, Mrs. Brown, if you'd like to step forward and take a seat. Thank you. So I understand is this essentially a copy of what you'll be reading out to me now, and then what's this I've been given here, the Maidstone Place strategy. Have the other parties had the opportunity to see this document? This additional place strategy, which I assume seems to be draft. I haven't had the opportunity to read this before. Do you think?
So if I can assist, I'm not sure I have a copy, but if it's a document that's referred to and the Parish Council want to refer you to, we, with a few minutes, can arrange for copies to be provided. We can get some copies made if that's going to assist proceedings.
I think that would be beneficial, just so people have had the opportunity to have a look at it first. If we get a copy of that, we'll have a short break now, perhaps just until 11 o'clock. You can have a copy of it, you can have the opportunity to read through it. If you've got any comments on it.
The other alternative, sir, it's not my practice to cross-examine third parties unless there's an exceptionally good reason for doing so. So I'm quite happy for you to proceed to listen to what the Parish Council has to say, and I'll certainly have the opportunity before Mr. Ross gives evidence, and he would deal with it in his examination in chief, to be able to read it overnight and consider it. So I don't need a break from my part, sir, so I'm really in your hands. It was just to make sure I had everything you had. Okay.
In that case, to perhaps a smoother running of events, I can get you a copy after this when we have the lunch break. And thank you for that, Mr. Headland. Happy with that.
We'll facilitate that in due course.
Yeah. Thank you, Mrs. Brown. If you'd like to start now, thank you.
Sorry to have caused.
No problem.
It's actually only one line in the whole document, but we thought we'd give you the whole document. Thank you, sir, for allowing us to speak on behalf of Yalding residents today. Following its written representations regarding the appeal, Yalding Parish Council continues to have objections and some concerns relating to the appeal proposals and the unacceptable adverse impact they will have in particular. Number one, on the character and setting of the village in landscape and design terms. We have read the proofs of evidence of the planning officer and Mr. Kirkpatrick, and we wish to endorse the comments made in those proofs of evidence. Number two, on the likely potential impact on local road conditions and capacity arising from traffic generated by development that is car biased and does not emphasise sufficiently promote sustainable transport. The appellant has suggested giving free bus tokens to encourage new residents to use the bus service. They would do better to maybe look at creating a foot/cycle path from Kenward Road to Yalding Station via a new footbridge across the river. Yalding is served with a fairly sparse bus service Monday to Saturday, whereas there are half-hourly trains on 7 days per week. The appellant only refers to parking on Kenward Road, whereas the parking problems are throughout the village. These have been exacerbated by H165 development at the Glebe on Vicarage Road, where curbside parking is being enforced against and forcing vehicles out onto the High Street and Kenward Road. These are mainly commercial vans. It is essential that the proposed development has sufficient parking for those using a car or commercial vehicle and for visitors. The appellant makes reference to Town Bridge and assures us that the number of car journeys to and from the proposed development will not have too much effect on the existing congestion that occurs, not just at peak periods, but on occasions throughout the day. Why does the appellant not offer to reduce the congestion caused by rat running and return the bridge to being a toll bridge using number plate recognition and free crossing to local residents? The proposal to create a walkway through Oast Court and create a crossing on the High Street has not been addressed. As YPC stated in its representations, the land through Oast Court is in private ownership, and my clerk, who is with us today, is joint owner with 2 other properties. Number 3, the precise use of the area of the site south of Kenward Road and how this can be achieved in a way that contributes to the needs and aspirations of the village and its residents as a whole, whilst ensuring that there is no adverse impact on the adjacent SSSI and the ecology and biodiversity. What is not in my statement is something that was referred to by the appellant earlier, where they state that Yalding has a deficiency of open space in both quantitative and qualitative terms. For your information, Yalding Parish Council owns 45.6 acres of common and amenity land, and actually owns 95.6% of all of the common land in the Maidstone Borough. Yalding Parish Council wishes to see Site B made a subject of discussion and agreement between itself, Maidstone Borough Council and the appellant. Aside from this hearing, and maybe a condition reference this could be attached. Surely it's for the Parish Council to know what the village requires in the way of amenity land. As an example, we do not need any further play equipment. Maidstone Borough Council's playground policy allows for the majority of homes to be within 12-minute walk of a play area, and making these areas strategic play areas, which will be supported by funds from Maidstone Borough Council. In the summer of last year, Yalding Parish Council completely replaced the play equipment and safety surface at the Kintons at a cost of approximately £140,000 plus incidentals. The proposed development is within a 12-minute walk of this play area. We are currently looking to increase the areas for sport in the parish, as well as YPC already owns large areas of both common and amenity land. Much of it is in a flood zone 3B and subject to severe flooding during the autumn-winter months. Drainage and flood risk issues, number 4. Yalding Parish Council remains extremely concerned that no detail has been provided with regard to the numerous natural springs below the Greensand Ridge and how these might be affected by the development. There is already a problem on Vicarage Road where, again, below the scarp of the Greensand Ridge, a development of 30 houses has been built in recent years, and alterations to landform and permeability have resulted that during winter months the road is lying underwater, which freezes in the colder weather, making driving conditions treacherous. Given the relationship of the appeal site to Kenward Road and the topography and known presence of springs, this needs to be fully examined, please. Thank you.
One question I did have for you was, how do you feel that the appeal scheme would impact on the adjacent triple SI? One of the points you raised here under 3 was that you wanted to ensure that there's no adverse impact on the adjacent site of special scientific interest in the ecology and biodiversity. You want to talk me through how you feel it might impact on?
It will be the river belt on site B.
How do you think that development would impact, I presume, adversely?
This is why we would like to have a roundtable discussion to look at the full use of that land as amenity land and what can be put on there, what we need and what will not impact on that triple SI. I think you can quite clearly segregate the triple SI from the rest of the land, but it does need to sit down and look at it together.
So is that concerned primarily around the sort of flood alleviation measures?
Yes, there is, the South East Rivers Trust have set up a catchment, it's just changed its name, so I can't remember what it is, which is looking at the whole of the belt, and this piece would come into under that umbrella, and again it would be something for us to talk to them about in whatever use we put that land to.
Okay, thank you. Mr. Tucker, do you have any questions? He said.
I don't, sir, but just can I give you 2 references which may be of assistance? The first of which is the Ecological Consultation Responses Core Document 7.6 from Kent County Council. And the second point, sir, is exactly the point that, if I may say so, Mrs. Brown rightly picks up, which is that there needs to be control with regards to the use of the open space. At the moment, that's a point that is proposed within the draft set of conditions, so I don't know if it would be helpful for Mr. Ross to send the parish clerk the draft conditions as they currently are, and that's a matter that obviously we'll be discussing later in the inquiry. So if that's helpful, I'm sure that's something that we can do, but I've got no questions. Thank you, sir.
Again, thank you, and yes, I'm quite happy to be included in that discussion on the draft conditions that will take place later in the inquiry, which we've got timetabled for, which I think was shared on the council's website, the draft timetable I had. I have that down on Thursday afternoon currently, if you did want to attend that roundtable discussion then as well. And that, thank you, I have no further questions for you, thank you. With no other interested parties wanting to speak, that gives us an opportunity to break early for lunch and perhaps just come back early for lunch so there's no pressure on us this afternoon. Happy with that?
I'm looking at 11 o'clock. I'm entirely comfortable with starting landscape now, after a mid-morning break. But I'm in my own friend's hands. Seems a shame to take a lunch at 11 o'clock.
Indeed, but equally so, I have a preference not to break up people's examination more than I necessarily have to, particularly some of the new guidance around discussions and the like of parties when they've given their evidence. But what do we have down for timing-wise? If you're going through examination in chief for approximately 60 minutes, you could quite comfortably get to that before lunch, and then it just means your witness is in splendid isolation for lunch. Are you happy with that?
So, I mean, I'm quite flexible. I was perfectly happy with your approach as it stood. If we want to move things around, we can, but yeah, your approach seemed fine to me, so as you set it on the timetable.
Fine. Let's have a short mid-morning break, and then we can crack on in, and we've got no time pressures at all that day. And if we break,
Yes, we'll get through
point,
Mr. Kirkpatrick's evidence today.
Yeah. Fine. Okay. Well, let's have a short break then until 11:15, and then we can come back for landscaping. Thank you. We'll adjourn there. Thank you, and apologies for darting out. It is just unfortunately necessary these days, and I will be particularly cautious about speaking to any of the parties separately or privately, only because one of my colleagues was even taken to the High Court because he was perceived to have been too friendly with a party on the site visit. So we are more cautious than ever before to remain impartial and to be seen to remain impartial. So thank you. That's apologies again.
Mrs. Brown did, however, point out to me when we had a conversation that it was difficult to hear from the back. I think there's an echo in relation to the microphones. So I don't know if it may be sensible to allow third parties to move forward a little bit, or perhaps try without microphones. I don't know.
Yes, absolutely. I'm happy to do either of that and would encourage you, first and foremost, to move forward. I'm particularly aware the witness will be speaking directly to me and away from you. So if you would like to, yes, bring yourselves forward. I know there's spaces on the end of that bench there if the council are happy with that.
Absolutely, sir. There's, 5 seats there? Please take all of them. That's absolutely fine. If there's more, put them behind. That's fine. Yeah.
Thank you, that's much appreciated. Yes, if you'd like to move forward so you can hear proceedings. Thank you. Mr. Henderson, I've got Mr. Kirkpatrick's proof of evidence. Should I have a copy of anything else?
You'll need Mr. Williams' proof of evidence as well, sir. I'll have to make reference to that. They are the 2 principal documents for the purposes, and the DAS as well, CD 5.4. Those, there may be a few others, but they will principally cover the matter, sir.
Apologies, my core document library is not accessing the document at the moment.
That's fine, sir. Just let us know when you're ready. It's important you've got these.
Sorry, Ms. Henderson, I've got the documents up now, but I'm concerned with the core document not working. The core document library. Has anyone else been able to access that?
I've just clicked on myself. I'll just refresh the page. It looks okay to me.
Okay.
I don't know if one of the defenders got it up and running.
Yeah, just out of caution, I always try to put them on a WeTransfer and download the files in any event. So I'm not accessing via the council's website. If others on my left are, we can perhaps check it over lunchtime.
Okay. Well, Mr. Kirkpatrick, you've got the core docs yourself, haven't you? Yes. Okay. Well, if you've got them and Mr. Kirkpatrick's got them, and I know the defender's ready, then I think we should probably make a start if that's acceptable. Mr. Kirkpatrick, I'll start by introducing you, please, by reference to your proof of evidence, page 2, PDF page 3. You set out in your section 1.1 your qualifications and experience. You explain that your name is Stephen Kirkpatrick, and your role is to provide the landscape and visual evidence on behalf of the council. You have a Bachelor of Science degree from Dundee University and a Bachelor of Landscape Design degree from Manchester University. You're a landscape architect, a chartered member of the Landscape Institute, and a Director of SCARP Landscape Architecture, which is a landscape architectural and environmental planning consultancy based in Henley-on-Thames. You explain in the next paragraph that your professional experience as a landscape architect spans more than 30 years, includes both the private and public sectors, and your experience covers a broad range of project and development types, but your main specialisations are in the field of environmental planning, landscape assessment, and landscape and visual impact assessment. You explain that you've undertaken numerous consultancy studies concerned with the balance between development and landscape conservation, including landscape sensitivity and capacity studies undertaken on behalf of local planning authorities to inform emergent development plans. You presented landscape and visual evidence at numerous public inquiries that have considered wind farm, residential, commercial and mixed-use development proposals in sensitive rural landscapes. And then we have your professional declaration in the final paragraph of that section. Is all of that correct?
It is.
Thank you. Can we start, please? The first topic is the allocation and the approach to that. And I want to ask you specifically about some of the calculations that Mr. Williams has done. So go please to his proof of evidence, paragraph 6.2.2, which you'll find on page 26 and it's PDF page 28. And in that paragraph, Mr. Williams does a calculation, 3.3 hectares, which is what he says is a reasonable interpretation of the site allocation. And he sets that against the proposed development. And he says that in the second sentence, this is only 0.02 hectares less than that proposed within the appeal scheme. I want your view, please, on that difference. What is your comment on the difference in terms of the calculation that Mr. Williams has done there?
I think the one comment that I do have on his calculation is that he has, in arriving at his net developable area 3.33, he's excluded the play area quite correctly, but included structural landscaping, which I don't think is appropriate.
Right. But just on taking that, so we'll come back to that, but on the face of this, the 0.02 hectares, is that a material difference in your view?
It is a material difference. The issue, the council has a concern over the density and the character and the appearance of the appeal scheme, and the 200 square metres that is represented by that figure means there's less interstitial green spaces that could be provided within that development area. But I think it's not just this issue over the 200 square metres, it's also the issue of the effects of density, of the increased density on opportunities to provide internal green spaces. And I think I'd just like to take you through my calculation of the effects of that additional 112 units of housing. So at 30 dph, we would have a figure of 333.3 square metres per house. At 30 dph, we have a figure of 333.3 square metres per house. Then, if we look at the 33.4 dph, that figure drops to 299.4 square metres per house. And that gives us a difference of 33.9 square metres. Now, if we spread that over the additional 112 units, that gives us a figure of 3,796.8 square meters. And if we could perhaps round that up to 3,800 for the ease of this discussion, and we add then that additional 200 square meters that arises from that variation in net developable area, that gives us approximately 4,000 square meters of space that we could play with, assuming that we stick to the plot sizes that are proposed in the appeal scheme. Now, the question then is, what is the effect of not having those 4,000 square meters of green space? I do mention in my proof of evidence the various green spaces within the existing village, and there is, as part of our site visit, I think part of the route takes us along Oast Court, which is directly to the pretty well directly to the southeast of the appeal site, and there are in that development on its northern edge various public realm green spaces. Some are 10 by 5 meters, i.e. 50 square meters. There's another one that's 20 by 5 meters, which is 100 square meters. So essentially, we could have there is the opportunity of incorporating 40 additional green spaces and distributing those across the built development area. And each of those could accommodate 2 large-scale trees, or alternatively, we could have 80 of the smaller green spaces. But the important point is that these additional green spaces that could have been provided would make a big difference to the character and appearance of the allocation site, both internally, both in terms of internal views and external views. And so a lot of the pressures and concerns that were expressed in the pre-application inquiry stage in terms of issues such as the prominence of parking courts, etc., would be alleviated and mitigated. Another way of looking at it in terms of that 4,000 square meters green space is if we look at the planting corridors that are proposed, both north-south and then relatively smaller ones on the east to the west, and the one leading from the entrance area heading northeast towards the central spine, those are a total of 385 meters long. Mr. Williams points out that they are 9 points. These are the lengths of the planting corridors as shown on the parameter plan. Would it be helpful if I...
Yeah, let me take the inspector to the relevant plan. So if you go, please, within this core document, it's CD 5.18, is the proposed parameters plan. I'll just wait until the inspector grabs that on his screen, and then just so we're very clear, you're referring to planting corridors, and just identify those on the plan, the parameters plan, please. I think the inspector might be there. So do you want to just go ahead? You've talked about planting corridors at 385 meters in length. Just clarify the ones that you're referring to, please.
Okay, so on the parameter plan, we can see in a green dashed line the indicative alignment of the planting corridors. And there are 3 of them. The primary one is basically north-south through the scheme. And that section of planting corridor within the built development area, I measure at 240 metres. And I've been working off two sources of information. One is Google Earth, and secondly is the quite a useful plan in the proposed habitat plan, which is scaled at 1 to 3,000 based at A3 size. And I'm happy to pass that around with a scale rule if that helps to confirm those figures.
Okay, so that's the first measurement. What was the second measurement that you were going on to explain?
So the second measurement is the green space that heads east from that central spine, and that is 65 metres long. And the third measurement is 80 metres, and that is for the planting corridor that heads within the built development area from the arrival space northeast to meet the central spine.
Right. And what should the inspector take from that, please?
Well, my point is simply that with the 4,000, looking at the difference in numbers of houses and density, we've got a difference in terms of green spaces of potential public realm green spaces of 4,000 square metres. Now, the total area of those planting corridors, 385 times 9.7 assumption based on Mr. Williams' figures, that gives us a total of 3,734 square metres. So my point is that the increase in numbers associated with the appeal scheme means that it is not possible to, the difference in the size of the plot sizes is such that it would have been possible to more than double the length of planting corridors within the built development area. And as a result, the character and the appearance of the appeal scheme, as experienced both internally and externally, would have been a much more positive experience.
And if we were, you've explained that calculation, but even just on the simple basis of Mr. Williams' 200 square metres, even just on that basis, where does that take you? You said to me that was material. Why do you say that was material, even on that basis?
Well, the additional 200 square metres also gives us an opportunity of increasing the peripheral planting, and it gives us broader the opportunity of wider green spaces, for example, along the western green space corridor.
Can we go within Mr. Williams' proof of evidence to his paragraph 4.2.4, please? So you'll need to move back in his proof to get there, which you'll find on page 10, PDF page 12. This is on the same, he explains the calculation, but then he goes on and makes a further point in this paragraph. She says that based on this net developable area, the maximum applied for 112 homes leads to a maximum density of 33.4 dph. In his view, that density has been low to medium for a location such as the appeal site, mindful of government's policy to use land efficiently. Your view, please, on that density and his comment that is low to medium for the location.
I think that I wouldn't consider the appeal scheme to be a low to medium. I think it's better described as a medium density scheme. But the more important point is that it is out of kilter with the densities in the surrounding area. And if I go then back to my proof, at paragraph 3.12 to 3.16.
Okay, so that's 3.12 to 3.16 on pages 8 and 9 of your proof, PDF 9 and 10. And what should we take from this analysis?
Well, what I set out here is to look at how the village, the structure of the village, looking at the north-south orientated high street and the connections between the two parts of the village, and pointing out the relatively old central and western parts of the village being designated as a conservation area. And then I go on to the issue of density and point out at 314 that south of Kenward Road and Vicarage Road, buildings are typically low density, including those on both sides of High Street and Oast Court. And at Oast Court, we've got predominantly detached housing, but including a terraced. And I provide apologies, there's a typo there, average net density of 10.44 dph. So I don't find that the appeal scheme responds sensitively to that relatively low settlement edge density. And then I go on to talk about, in the southeast quadrant, a higher density cluster of housing, and that's called the glebe, and I think that is pointed out, identified in Mr. Williams' urban design proof, where he gives the names of some of these development areas in his, let me just find, and that's Appendix A, where he addresses in his rebuttal proof settlement, evolution and pattern. And we can see on page 45 there,
yeah, page 45.
We can see there the relatively modern developments of the glebe in purple, and Hawthornden Grove also in purple on the northern side of Vicarage Road. So those I describe in broad terms in my proof. So going back to 3.14, I talk about the higher density cluster of housing. The glebe is located on the edge of the southeast quadrant, where the land is low-lying and abuts both a wood and mature trees associated with a moat. So it's a different landscape context for that development, but that cluster of housing is at 26 dph. It's not a figure I put in my proof, but I've subsequently looked it up, and I can give you, sir, the planning application reference if that's of assistance. Then I go on in para 3.15 and describe the northeastern quadrant.
All of which Mr. Williams will have to check. Can I just lay down the marker? Telling an inquiry that we can have the planning reference to work that out as to what the figure is not an acceptable way of giving evidence. This is not a matter of pulling rabbits out of hats. We ought to know this in advance. So can I just, I'm not objecting to the receipt of this, but I do say that if we get more figures that we have to run away and check, then that will cause problems in terms of the smooth running of the inquiry. For example, the 3,800 square metre figure and the assessment of 4,000 with a distance of 385, none of that I'm going to do, none of that's in the bundle, all of which we'll have to check at lunch.
Thank you, I appreciate that point. And Mr. Fitzpatrick, I'd be grateful if you could take a steady pace going through these points, particularly if I've got to make notes of them as well. I'd be grateful for that.
Yes, sir.
So, Mr. Fitzpatrick, you dealt with the Oast, and with the spectre's mind, let's just go that. So you dealt with Oast Court at 10.44, the Glebe at 26 dph, and you were moving on, I think, in your you just now turn into your 3.15 and your 3.16 on top of your page 9. And the points that we should take from that in terms of density, please.
Yeah, so let me finish on 3.16, where I simply point out the average net density of the northwestern quadrant, which abuts the appeal site, and point out that's 21.29 dph.
So in that context, what is your view on the density proposed here?
Well, clearly there is a big difference in density between the allocation and the existing settlement, but an even greater difference between the appeal scheme and the existing settlement, and that has effects on the character and appearance of the area.
Right, we'll come on to those. Let's work through now your approach to those effects. So topic 2 that we need to deal with is the settlement of Yalding itself. So in your proof, you've already taken us through the first part of that, your analysis of the different densities within the built form. But now on to your next subtopic, please, of trees and greens. What are the relevant pertinent points from this, please? So your page 9, net subheading trees and greens.
Okay, so in this section I have basically made a reference to the Yalding Conservation Area Appraisal, which sets out the valued characteristics of the conservation area, and much of this applies to the wider village, but the paragraph 11.6 where it states that trees and green landscape are really significant contributors to the feel of Yalding and the quality of the environment. I then go on at paragraph 3.19 to say that I consider garden trees also provide a notable contribution to village character and the well-treed skyline of the village. Then point out that one of the key green spaces in Yalding, which is at the village green, it is relatively large in size compared to most other green spaces within the built-up area. It supports half a dozen visually prominent large-scale trees that contribute to the well-treed skyline of the village. So, really important part of the character of the settlement.
And then if we move on, you deal with approach roads to Yalding. You deal with these from a number of different directions, but I want to ask you specifically approaching from the west. As you say, your 3.1.12, that's not described, but you go on and you deal with Kenward Road in your section 5 below. Can you explain, please, to the Inspector, the approach along Kenward Road to the west and the key points in that regard, please?
Yes, okay. So I think just stepping back a little, is that in terms of the character of the village and how the roads and approach roads make a contribution to people's appreciation of the landscape setting of the village, one theme that comes out strongly for me is that approaching from the north, the village comes into view without any pre-warning. From the southwest, at the last moment, the village comes into the view. And this is an integral part of the character of the village. I describe the approach from the west at my para 5.14.
Yeah, so that's the bottom of your page 17, PDF page 18.
And I make reference to various photographs, but if we look at photographs M.
Yeah, so we can see that in your appendices, your photograph M. I have your, well, it's a PDF reference, but on your PDF page 50, halfway through your appendices, end of Appendix A,
And I think what the photograph M shows is a long vista along Kenward Road, directly towards the polytunnels, a glimpsed house of the rooftop of one of the houses on Medway Avenue, and a backdrop of both the cypress hedge and garden trees that serve to basically enclose views of the settlement. And the point I make that whilst you can see the roofs of two of the houses there, it's not necessarily an indicator of having arrived at the settlement, because along Kenward Road there are intermittent farmhouses associated with the agricultural landscape. And this is one example where polytunnels are seen in association with built form. And so at the moment, one does not have this long approach or appreciation that one is approaching the settlement. It is more of a sudden sense of arrival when one passes passes through the appeal site and arrives at the existing Kenward Road housing.
Right. In that context, I want to ask you about the characterisation in the LVIA. The LVIA in Appendix B in respect of LCA 38 refers to the site as having a settlement edge character. What's your view on that description, please, of the appeal site?
I don't agree with that assessment. I think the site, because the existing settlement has a high degree of visual containment because of the garden trees. Because the existing settlement has a high degree of containment, rising from the cypress hedge and garden trees, it's difficult to consider, inappropriate to consider that as having a settlement edge character. It seems to me that it's clearly within the countryside, although within a polytunnel agricultural landscape.
So that's your appraisal in terms of the settlement of Yalding now. Let's just think also about the visual context. The next topic, please, is the visual context of the appeal site. You deal this in your proof of evidence at your 7.21 and so 7.2.1 that is, and 7.2.2, which is on your page 24, PDF page 25. What are the key points, please, in terms of the visual envelope for the appeal site, in your view?
Well, I think the LVA considers that the site has a relatively limited visual envelope and identifies that on figure 6 of the LVIA, I believe. And my point is that that visual envelope is in fact a lot more extensive, and you can see that it's indicated by my photograph H, where there are wide panoramic views across the low weald from within the site, and also the description that I provide in section 8.3 of my proof, where I describe a ZTV that I ran using Google Earth view sheds.
So we see that on your page 32, your plate 9, I think is what you're referring to here. That's PDF page 33. Just help me with this. Mr. Williams, in his rebuttal proof of evidence, commenting on this paragraph, says that this is a bare earth ZTV, which he considers to be misleading. What is your response to that, please?
I don't consider that to be correct. Google Earth view sheds are run on the basis of LiDAR data. So if you take, for example, an agricultural landscape and plant a test point beside a block of woodland and run the view shed, that woodland will truncate views in that direction, and you would get extensive views potentially in all other directions. So it takes into account existing structures and vegetation, both buildings and trees, woodland.
And therefore, on the comparative basis of this plate and what we see in the LVA, what do you say about the comparative visibility on that basis?
Well, I think the visibility of the built form is much more extensive than shown in the LVA figure 6. It does make the note that actually it makes the distinction between primary and secondary visibility, and the effects of the built development be outside a primary visual envelope being less significant. But nevertheless, I think it's not accurately identified the extent of visual influence of the built form, and that's of particular concern with regard to the Green Sand Ridge LLV, where the visibility crosses a much more extensive area on the northwestern, northern and northeastern sides of the appeal site. And whilst there is only one public right-of-way through there, there are private residential properties, and it is a working agricultural landscape, and people experience views from that elevated landform, and that's all part of the setting of that LLV. It is about intervisibility, how you appreciate views outside the LLV, and how looking back towards the landform that is within the LLV, that's also part of the setting.
Right. And just pausing there, put to one side the question of ZTV and bare earth and LiDAR. What does your site visit experience tell you about the visual envelope of the appeal site?
Well, the visual envelope of the appeal site is more extensive than has been identified, and it's correct to say that that when you go beyond a certain distance, the visual effects become insignificant. But I think what the LVIA has not picked up fully is the even the near and middle distance views, and I do mention in my proof at 843 that it's an obvious point that visibility from the mooring area at Little Venice Country Park, it's shown as being outside the area of visual influence, but you can see from the Country Park website that there are clear views of the appeal site polytunnels.
And what does that then mean in terms of the utility of the LVA as a tool for the urban designer?
Well, I think there's two issues that arise from that. One is that if one accepts that the increase in density of the associated with the appeal scheme over the allocation is harmful, then the extent of landscape and visual harm is greater. And the second point is it's not fully picked up all the receptors.
So I want to turn then to topic 5, the design approach, and you have a number of comments on the DAS in your proof of evidence. I want to look at some of the pages that you refer to. So the DAS, please, CD 5.4, page 20, which is also PDF page 22. So DAS page 20, please. And when you're there, you'll see, Mr. Kirkpatrick, that this deals with a subtitle landscape analysis, and we have 3 images and then some text. What's your comments, please, on this part of the DAS?
Well, as I point out at 8.21, I think the landscape analysis is too limited in its scope and detail to properly inform the master planning exercise. I think that that analysis should have identified the maximum elevation of built form within the appeal site that should have been that would be acceptable and more given consideration, far greater consideration to the character of the existing village in terms of the layout of buildings, green space and trees. And I point out that it's this lack of in-depth analysis that's led to all the three initial options for development on Site A being very similar. So I'm not sure that how robust that or informative the LVA has been. It wouldn't appear to have guided the layouts to any notable degree at that point.
So let's have a look at those options you just referred to. So that's page 24, PDF page 26 in the DAS. We see the initial options 1 through to 3. So just illustrate the point that you were making, please, about those options for the inspector. It's under the subtitle Design Evolution, and then the subtitle is Initial Options.
Just opening the DAS now, apologies.
So when you're there, it's PDF page 26, internal page 24.
Page 26, did you say?
Yeah, type 26 into the electronic numbering. And you'll see Design Evolution Initial Options, and you were just referring to these a moment ago.
Okay, I'm on page 26 now, which is engagement and consultation.
It's PDF 26, so internal 24, so go back 2 pages, you get Design Evolution Initial Options.
Okay, Design Evolution.
And you were referring a moment ago to the comparison between these 3 options. I just want you to illustrate the point you're making, please, in terms of these 3 initial options.
Looking at all 3 options, they take built development up to quite a high elevation within the site and give very little room for any meaningful green space along the northern site boundary. They are all identical in that respect. The options vary elsewhere within the Site A, the northern part of the development site, in terms of the width of the western green space corridor, but the east one is exactly the same. The other 2 options 2 and 3 include built development within the southern part of the site, appeal site, i.e. Site B, which is not in accordance with the allocation. Option 1, again, is not in accordance with the allocation, as it doesn't provide the recreational green spaces that are required under that allocation.
We then get over the page 25, PDF 27, 2 further refinements. What are your comments, please, on these refinements in terms of the design evolution?
Well, I've pointed this out in 8.22 of my proof when I refer to the northern green space now being widened to a much broader area, which I think is the correct approach. The variations between the vision document and the further refinement are in terms of whether or not it's in the vision document it's scattered trees within an informal green space. The further refinement narrows that green space, but attempts to provide a dense edge along the northern part, so separating the northern green space into a visual screen and an informal green space on the northern edge of the built development area.
And in terms of the response to the settlement, what would you say about these options in the design evolution process on that front?
Well, I think in terms of the assessment in the LVA, I think it's not really teased out, I think, the sensitivities of the site in terms of the need for a softer edge to the expanded settlement. And I think one would have expected a greater transition between the built development area and the surrounding countryside, particularly to the west. One would have expected a greater consideration given to densities, and I would have expected a transition of densities moving from east to west to that sensitive western edge. Right. And I would have expected more refinement to the entrance to the site, and keeping a very bold and strong landscape structure at that entrance, so that the built form is not prominent on the western approach along Kenward Road.
They're your comments on the revised option there. If we skip forward, please, to what is now presented, so that's PDF, that's page 49, PDF page 51, same document, the DAS. We have focusing now on the northern parcel, and we have a series of design principles in the key 1 through to 10. Are your comments the same in respect of what we see here, or were they different?
Well, I think in terms of the design principles, I think they've enlarged the arrival green space, but I'm still of the view that that is not large enough to serve its function, which should not be to have the buildings visible when looking southeast along Kenward Road, but they should be there should be a stronger green space, so that one achieves a sense of arrival when coming at the entrance to the site, and prior to that, the built form should not be prominent. I think also the built form needs to be much more fragmented along the edges. It's simply too dense, in my opinion. It lacks interstitial green spaces that break up the development, both in terms of its internal character and appearance, and the appearance of it from external views. Now, we've got this north-south, we've got the green spine. Those work in terms of how you experience landscape and the sense of green spaces within the development, but I don't think they're sufficient for achieving landscape and visual integration. It's the built form is simply too dense, and it needs to be broken up further. And then we've got various issues over privacy for houses that abut the eastern green space. I don't think that's good design when you've got an issue over people walking immediately beside the window. There should be some concept of defensible space.
Right. So in light of what you said about the design process, I want to now look at topic 6 and final topic, the effects of the appeal scheme. The first one that I want to pick up is in respect of your comments about the eastern green space, and we actually see that marked number 10 on the plan that we were just looking at a moment ago. What's your view, please, on the eastern green space?
Well, I think it's. I think we have an appeal scheme that is simply too. The grain is simply too tight. The houses are simply spaced too closely together. And I think, as I pointed out in my proof, I think there was perhaps a missed opportunity for narrowing the eastern green space. So it becomes, and that would allow the root protection areas to be respected, but you could narrow that corridor quite notably. And I think the arrangement of houses should be that rather than having one section of road immediately abutting the green space, and elsewhere you've got flank walls and windows and side garden fences abutting it. I think there was an opportunity that should have been considered in more detail, of having a continuous road along that green space and working the development out from there.
What would that have meant then at this outline stage in terms of the parameters plan?
Well, it would have meant that the parameter plan is not appropriate in that sense, because it's taking valued green space and parking it along the eastern corridor, where it could be better distributed elsewhere, either within the built development area or along the western green space corridor on the periphery of the site. So the distribution of green spaces is in my opinion, not correct.
Right. Picking up on the next point, you've touched on it already, one of urban grain. You deal with this in your proof of evidence at your 8.29, 8.210, and indeed 8.211 on your pages 28, 29. What is your concern in terms of the effect of the proposed development on urban grain?
Well, I think as I say in 8.210, the illustrative site layout shows a much tighter urban grain than the existing village, and that's tighter than the allocation, which is for a lower number of units, and the consequence of increasing housing numbers is that you get a much more constrained layout, where you get reduced variation in orientation, a tighter arrangement of pattern in terms of the housing and their spacings. And this is out of character with other parts of the village, including the nearby Oast Court, which has got that significantly lower density. It's also resulted in a reduced opportunity to provide more street planting than could be provided, and a reduction in the variation in terms of house setbacks and provision of front rear gardens, that all of which potentially would have added to the richness of the development. And it's really the concern being of the uniformity of so much of the development that is of concern to the council, and that is arising from the uniformity of plot sizes and basically the narrowing of opportunities in terms of green spaces.
And so if this was stepped back from 112 at 33.4 dph down to 100 dwellings at 30 dph, what is the sort of effect that that change might have on your concern here?
Well, I think it would significantly alleviate those concerns, because if you start looking at 4,000 square metres of additional green space, we are able to break up the density and grain of the development with more interstitial planting, both along streets, corner plots, and along the sensitive western edge, where you could then bring green spaces in from that western peripheral corridor, which is quite constrained by the time one takes the tractor access into account and so on. So the opportunities for vegetation going there are limited, and if one took green spaces going into the built development area, you can then start achieving that visual breakup and a much more feathered effect of housing and green spaces.
Okay, I want to follow that through in terms of interstitial vegetation, but let's start please with your section 8.3, where you address this on your page 29, and you have a number of criticisms that you make about the photo montages, in particular that your 8.3.3 through to 8.3.5. Just summarise, what are those concerns please about the photo montages that have been provided by the appellants?
Well, I think they're not technically correct insofar as they are unrealistic. They've modelled the vegetation for the woodland at 12 metres in height. I estimate at para 8.33 that the woodland would reach no more than 7.5 metres in height by year 15. And then at 8.34, I then make the point that the continuous corridor of greenery through the central part of the built-up area, parallel and downslope of the modelled northern woodland, is also not realistic. So my overriding point is that by year 15, we don't achieve this visual degree of visual enclosure that is suggested, and the appeal scheme will appear as a dense visual mass of built form of uniform height. Nor does the trees within the internal areas serve to break up that visual mass because of, I think, the density of the housing. It's so compact.
So dropping the density down, that 33.4, dropping that down to the 30 dph, what sort of effect would you expect that to have?
So you could repeat the question?
Yes, you raised a concern about the density and what it permits, so dropping it from 33.4 as proposed now to 30 dph, what effect would you think that would have on your concerns that you've just expressed in terms of the planting?
Well, I think the concerns are that it would allow in the case of the western green space, it would allow a much more varied structure of vegetation along that sensitive western edge, so that one doesn't come up with a continuous wall of vegetation of a certain height, and of a very rigid layout. I think there's an opportunity for bringing vegetation into the built development area, so that that rather rigid green wall would be much more softer and sinuous than is proposed. I'd also make the point that actually the woodland along the western edge is not realistic, because that vegetation is likely to be thinned out at that proposed density by year 15. So you've really got an expanded settlement edge that is going to be visible. The western edge vegetation structure will soften it, but I think the concern is the degree of the slightly incongruous appearance of a continuous edge without variety and without depth that really kind of emphasizes the presence of the settlement. I think there could be a much more softer and feathered edge, much more variation within the built development area, including variation of density from east to west, that could provide a more appropriate edge.
All right, thank you. And then in terms of the parameters plan, just going back to that, you've expressed a concern about density, which we know is the numbers of dwellings in the areas that are spread. What does that mean in terms of the effect of the parameters plan in light of the concerns that you've just raised?
Well, I think there are two issues with the parameter plan that I've touched upon, and that is both in terms of the widths and distribution of the external green spaces, and then the issue over the density within the built development area, and the consequences of that in terms of character and appearance. And then related to that is the degree to which the built development area could be broken up further through interstitial planting to achieve more of a visual mosaic of buildings and vegetation when, as experienced from surrounding viewpoints, both from the southeast and from the LLV.
And is any of that provided for in the parameters plan in its current form?
Pardon?
Is that provided for in the parameters plan?
No, it strikes me as far too rigid a parameter plan. I would have expected for this quite sensitive hillside site a parameter plan that perhaps was a more appropriate distribution of green spaces, reduced density, less blocky, and I mentioned the what I think is important in terms of green spaces penetrating the built development area from the west, and as previously said, there's I think a lost opportunity for redistributing the peripheral green spaces from east to west.
Right. Thank you. So they're my questions, almost bang on the hour.
That brings us up to 12:20. So we're happy to break for lunch there and resume cross-examination. Any questions? Then, a couple of items for housekeeping. We're going to get a copy of this, if that's okay. If we can get
the photocopy will be fired up over lunchtime, and we'll get some copies of that.
And I would be grateful if the council could work out how to turn off that light up there, which is happily crackling away.
So the light in that one up there, okay.
That white one up there. If you can do that. The more I've listened to it, the more it's annoyed me.
No, that's why it looks like it's
that could be done.
not functioning. We'll get on to that.
Thank you. We're happy to adjourn there until 1:30.
Yes, so just to make the point, you were also promised a copy of Mr. Williams' appendix from his rebuttal. in a larger form. So if I can have that handed to you as well, please, sir.
Yeah, thank you.